This video reviews the case Moore v. Regents of the University of California. So why is Moore relevant to property law? What's the purpose of us going over this case? Well, Moore discusses the right to transfer, believe it or not. However, it's the right to transfer a body part to someone else. And the underlying question is, should any body parts be considered as property? And if so, what rights of transfer should we give them? The case demonstrates how property rights can be acquired through creation and accession as well. The plaintiff of the case is John Moore. Moore underwent treatment at UCLA's medical school for leukemia. And in the course of treatment, he had blood drawn, and his spleen removed. Now, the physicians at UCLA knew that his cells had a particular value to them, but they didn't inform Moore of that fact. And without his knowledge, they used his cells in research, and they were able to use a particular scientific process to create what's called a cell line. Once they created the cell line, they applied and received a patent for it, and they then entered into an agreement with a company to capitalize on that. The sum of money that they were supposed to get was approximately, the market potential was estimated to be about $3 billion. Moore sued UCLA's medical center under a number of theories, including lack of informed consent, breach of fiduciary duty, and conversion. And it's primarily the third claim that I just mentioned, conversion, that we are most interested in for the purposes of this property law course. Now, the trial court sustained the defendant's demurs, but the California appellate court reversed. So now this case is at the level of the California Supreme Court. In order for the plaintiff to win on a claim of conversion, he would need to show interference with possession and ownership interests in personal property. Moore argued that he owned his cells even after their removal, and that he didn't consent to their use in medical research. So the physicians had interfered with his ownership interest. The court reasoned that Moore didn't have a possessory interest, which was one possibility. So once the cells were removed, no possessory interest existed. But the question remained over whether or not Moore had an ownership interest. So he might not have had possession, but then the question remained, did he have ownership? Well, the court said that there had been no judicial decisions that would support an ownership interest in cells that have been excised from the human body. They then said that previous cases placed policy considerations first, rather than applying laws of personal property. And I would argue that they did the same thing in this case. They decided to set aside the laws of property in an effort to further what they considered to be furthering public policy. The second major argument the court had was that California law limited patients' interests in excised cells. So once cells were removed, the court argued that although the California statute didn't explicitly address the facts that were presented in front of the court interpreted really what you could see as a spirit of the law as limiting the patient's control over the excised cells. So although the statute didn't expressly address the facts of the case, the court reasoned that the purpose of the law was to limit patients' control over excised cells. So in that sense, they applied what they viewed as the purpose of the law to the case. In the third set of arguments, the court argued that the cell line could not possibly be Moore's property. That so the cell line was the patent's subject matter. And so that was really the property that was at issue. And in the court's view, that cell line could not have possibly be Moore's property, that it was a completely separate and distinct piece of property from Moore's cells. The court then added to its analysis a public policy reasoning, and they argued that it was their job to balance informed consent with the possibility of deterring scientists from conducting research. And they portrayed scientists as performing this act that really benefited society. So the research itself was a social good, which is interesting, because if you look at the amount of money that they made, you could just as easily have framed the scientists as capitalists or persons that were out for financial gain. But that's not how the court viewed them. The court made clear that they feared that restricting access to these cells would decrease the amount of raw materials that were available to scientists to conduct their research. And they really feared that scientists would be afraid of potential litigation, and that would destroy their economic incentives and make them much more hesitant to engage in research that really could benefit society. So because of all of these reasons, the majority ended up holding that the complaint did not state a cause of action for conversion. The dissent took a different view. The dissent argued that Moore retained at least one stake of one of the stakes in the bundle, which was the right to transfer. Now, in the dissent's view, Moore could have donated his cells, and since he could have donated his cells, that meant that he really did have a right to transfer. He made clear that he felt that the majority could have still allowed Moore cells to be characterized as personal properties and just limited the rights to transfer that went along with it. So to basically make it so that it was market inalienable, which meant that it could not be sold on the market. However, it could be transferred by other means like donation. In sum, the majority and the dissent had very different theories of how the case should turn out, and you could see in how they reached their decisions and in their analysis. Now I'd like you to turn to page 48 of your book. Under section G, you'll see a section that says more problems. where it asks you to apply the principles for more in resolving the following hypothetical disputes. So I'd like you to spend some time doing questions 1 through 3 and submitting the answers in the link that I will provide you.